Family Code of the Philippines. Title 4. Property Relations between Husband and Wife. Chapter 1. General Provisions. Article 74. The property relations between husband and wife shall be governed in the following order. Number 1. By marriage settlements executed before the marriage. Number 2. By the provisions of this code, and number 3. By the local customs. Article 75. The future spouses may, in the marriage settlements, agree upon the regime of absolute community, conjugal partnership of gains, complete separation of property, or any other regime. In the absence of marriage settlement, or when the regime agreed upon is void, the system of absolute community of property as established in this code shall govern. Article 77. The marriage settlements and any modification thereof shall be in writing, signed by the parties and executed before the celebration of the marriage. They shall not prejudice third persons unless they are registered in the local civil registry where the marriage contract is recorded as well as in the proper registries of properties. Article 78. A minor who according to law may contract marriage may also execute his or her marriage settlements, but they shall be valid only if the persons designated in Article 14 to give consent to the marriage are made parties to the agreement, subject to the provisions of Title 9 of this code. Article 79. For the validity of any marriage settlement executed by a person upon whom a sentence of civil interdiction has been pronounced or who is subject to any other disability, it shall be indispensable for the guardian appointed by a competent court to be made a party thereto. Article 80. In the absence of a contrary stipulation in a marriage settlement, the property relations of the spouses shall be governed by the Philippine laws, regardless of the place of the celebration of the marriage and their residence. This rule shall not apply, number 1. Where both spouses are aliens, number 2. With respect to the extrinsic validity of contracts affecting property not situated in the Philippines and executed in the country where the property is located, and number 3. With respect to the extrinsic validity of contracts entered into in the Philippines but affecting property situated in a foreign country whose laws require different formalities for its extrinsic validity. Article 81. Everything stipulated in the settlements or contracts referred to in the preceding articles in consideration of a future marriage, including donations between the prospective spouses made therein, shall be rendered void if the marriage does not take place. However, stipulations that do not depend upon the celebration of the marriages shall be valid. Chapter 2. Donations by reason of marriage. Article 82. Donations by reason of marriage are those which are made before its celebration, in consideration of the same, and in favor of one or both of the future spouses. Article 83. These donations are governed by the rules on ordinary donations established in Title 3 of Book 3 of the Civil Code, insofar as they are not modified by the following articles. Article 84. If the future spouses agree upon a regime other than the absolute community of property, they cannot donate to each other in their marriage settlements more than 1/5 of their present property. Any excess shall be considered void. Donations of future property shall be governed by the provisions on testamentary succession and the formalities of wills. Article 85. Donations by reason of marriage of property subject to encumbrances shall be valid. In case of foreclosure of the encumbrance and the property is sold for less than the total amount of the obligation secured, the donee shall not be liable for the deficiency. If the property is sold for more than the total amount of said obligation, the donee shall be entitled to the excess. Article 86. A donation by reason of marriage may be revoked by the donor in the following cases. Number 1. If the marriage is not celebrated or judicially declared void ab initio except donations made in the marriage settlements, which shall be governed by Article 81. Number 2. When the marriage takes place without the consent of the parents or guardian, as required by law. Number 3. When the marriage is annulled, and the donee acted in bad faith. Number 4. Upon legal separation, the donee being the guilty spouse. Number 5. If it is with a resolutory condition and the condition is complied with. Number 6. when the donee has committed an act of ingratitude as specified by the provisions of the Civil Code on donations in general. Article 87. Every donation or grant of gratuitous advantage, direct or indirect, between the spouses during the marriage shall be void, except moderate gifts which the spouses may give each other on the occasion of any family rejoicing. The prohibition shall also apply to persons living together as husband and wife without a valid marriage. Chapter 3. System of Absolute Community. Section 1. General Provisions. Article 88. The absolute community of property between spouses shall commence at the precise moment that the marriage is celebrated. Any stipulation, express or implied, for the commencement of the community regime at any other time shall be void. Article 89. No waiver of rights, shares, and effects of the absolute community of property during the marriage can be made except in case of judicial separation of property. When the waiver takes place upon a judicial separation of property, or after the marriage has been dissolved or annulled, the same shall appear in a public instrument and shall be recorded as provided in Article 77. The creditors of the spouse who made such waiver may petition the court to rescind the waiver to the extent of the amount sufficient to cover the amount of their credits. Article 90. The provisions on co-ownership shall apply to the absolute community of property between the spouses in all matters not provided for in this chapter. Section 2. What constitutes community property? Article 91. Unless otherwise provided in this chapter or in the marriage settlements, the community property shall consist of all the property owned by the spouses at the time of the celebration of the marriage or acquired thereafter. Article 92. The following shall be excluded from the community property. Number 1. Property acquired during the marriage by gratuitous title by either spouse, and the fruits as well as the income thereof, if any, unless it is expressly provided by the donor, testator, or grantor that they shall form part of the community property. Number 2. Property for personal and exclusive use of either spouse. However, jewelry shall form part of the community property. Number 3. Property acquired before the marriage by either spouse who has legitimate descendants by a former marriage, and the fruits as well as the income, if any, of such property. Article 93. Property acquired during the marriage is presumed to belong to the community, unless it is proved that it is one of those excluded therefrom. Section 3. Charges and obligations of the absolute community. Article 94. The absolute community of property shall be liable for, number 1, the support of the spouses, their common children, and legitimate children of either spouse. However, the support of illegitimate children shall be governed by the provisions of this code on support. Number 2. All debts and obligations contracted during the marriage by the designated administrator spouse for the benefit of the community, or by both spouses, or by one spouse with the consent of the other. Number 3. Debts and obligations contracted by either spouse without the consent of the other to the extent that the family may have been benefited. Number 4. All taxes, liens, charges and expenses, including major or minor repairs, upon the community property. Number 5. All taxes and expenses for mere preservation made during marriage upon the separate property of either spouse used by the family. Number 6. Expenses to enable either spouse to commence or complete a professional or vocational course, or other activity for self-improvement. Number 7. Antenuptial debts of either spouse insofar as they have redounded to the benefit of the family. Number 8. The value of what is donated or promised by both spouses in favor of their common legitimate children for the exclusive purpose of commencing or completing a professional or vocational course or other activity for self-improvement. Number 9. Antenuptial debts of either spouse other than those falling under paragraph 7 of this article, the support of illegitimate children of either spouse, and liabilities incurred by either spouse by reason of a crime or a quasi-delict, in case of absence or insufficiency of the exclusive property of the debtor spouse, the payment of which shall be considered as advances to be deducted from the share of the debtor spouse upon liquidation of the community. And number 10, expenses of Litigation between the spouses unless the suit is found to be groundless. If the community property is insufficient to cover the foregoing liabilities, except those falling under paragraph 9, the spouses shall be solidarily liable for the unpaid balance with their separate properties. Article 95. Whatever may be lost during the marriage in any game of chance, betting, sweepstakes, or any other kind of gambling, whether permitted or prohibited by law, shall be borne by the loser and shall not be charged to the community, but any winnings therefrom shall form part of the community property. Section 4. Ownership, administrative, enjoyment and disposition of the community property. Article 96. The administration and enjoyment of the community property shall belong to both spouses jointly. In case of disagreement, the husband's decision shall prevail, subject to recourse to the court by the wife for proper remedy, which must be availed of within 5 years from the date of the contract implementing such decision. In the event that one spouse is incapacitated or otherwise unable to participate in the administration of the common properties, the other spouse may assume sole powers of administration. These powers do not include disposition or encumbrance without authority of the court or the written consent of the other spouse. In the absence of such authority or consent, the disposition or encumbrance shall be void. However, the transaction shall be construed as a continuing offer on the part of the consenting spouse and the third person, and may be perfected as a binding contract upon the acceptance by the other spouse or authorization by the court before the offer is withdrawn by either or both offerers. Article 97. Either spouse may dispose by will of his or her interest in the community property. Article 98. Neither spouse may donate any community property without the consent of the other. However, either spouse may, without the consent of the other, make moderate donations from the community property for charity or on occasions of family rejoicing or family distress. Section 5. Dissolution of absolute community regime. Article 99. The absolute community terminates, number 1, upon the death of either spouse, number 2, when there is a decree of legal separation, number 3, when the marriage is annulled or declared void, or number 4, in case of judicial separation of property during the marriage under Articles 134 to 138. Article 100. The separation in fact between husband and wife shall not affect the regime of absolute community except that, number 1, the spouse who leaves the conjugal home or refuses to live therein, without just cause, shall not have the right to be supported, number 2, when the consent of one spouse to any transaction of the other is required by law, judicial authorization shall be obtained in a summary proceeding, number 3, in the absence of sufficient community property, the separate property of both spouses shall be solidarily liable for the support of the family. The spouse present shall, upon proper petition in a summary proceeding, be given judicial authority to administer or encumber any specific separate property of the other spouse and use the fruits or proceeds thereof to satisfy the latter's share. Article 101. If a spouse without just cause abandons the other or fails to comply with his or her obligations to the family, the aggrieved spouse may petition the court for receivership, for judicial separation of property or for authority to be the sole administrator of the absolute community, subject to such precautionary conditions as the court may impose. The obligations to the family mentioned in the preceding paragraph refer to marital, parental, or property relations. A spouse is deemed to have abandoned the other when her or she has left the conjugal dwelling without intention of returning. The spouse who has left the conjugal dwelling for a period of 3 months or has failed within the same period to give any information as to his or her whereabouts shall be prima facie presumed to have no intention of returning to the conjugal dwelling. Section 6. Liquidation of the absolute community assets and liabilities. Article 102. Upon dissolution of the absolute community regime, the following procedure shall apply. Number 1. An inventory shall be prepared, listing separately all the properties of the absolute community and the exclusive properties of each spouse. Number 2. the debts and obligations of the absolute community shall be paid out of its assets. In case of insufficiency of said assets, the spouses shall be solidarily liable for the unpaid balance with their separate properties in accordance with the provisions of the second paragraph of Article 94. Number 3. Whatever remains of the exclusive properties of the spouses shall thereafter be delivered to each of them. Number 4. The net remainder of the properties of the absolute community shall constitute its net assets, which shall be divided equally between husband and wife, unless a different proportion or division was agreed upon in the marriage settlements, or unless there has been a voluntary waiver of such share provided in this code. For purpose of computing the net profits subject to forfeiture in accordance with Articles 43, Number 2, and 63, Number 2, the said profits shall be the increase in value between the market value of the community property at the time of the celebration of the marriage and the market value at the time of its dissolution. Number 5, the presumptive legitimes of the common children shall be delivered upon partition, in accordance with Article 51. Number 6, unless otherwise agreed upon by the parties, in the partition of the properties, the conjugal dwelling and the lot on which it is situated shall be adjudicated to the spouse with whom the majority of the common children choose to remain. Children below the age of 7 years are deemed to have chosen the mother, unless the court has decided otherwise. In case there is no such majority, the court shall decide, taking into consideration the best interests of said children. Article 103. Upon the termination of the marriage by death, the community property shall be liquidated in the same proceeding for the settlement of the estate of the deceased. If no judicial settlement proceeding is instituted, the surviving spouse shall liquidate the community property either judicially or extrajudicially within 6 months from the death of the deceased spouse. If upon the lapse of the 6 months period, no liquidation is made, any disposition or encumbrance involving the community property of the terminated marriage shall be void. Should the surviving spouse contract a subsequent marriage without compliance with the foregoing requirements, a mandatory regime of complete separation of property shall govern the property relations of the subsequent marriage. Article 104. Whenever the liquidation of the community properties of 2 or more marriages contracted by the same person before the effectivity of this code is carried out simultaneously, the respective capital, fruits, and income of each community shall be determined upon such proof as may be considered according to the rules of evidence. In case of doubt as to which community the existing properties belong, the same shall be divided between the different communities in proportion to the capital and duration of each. Chapter 4. Conjugal Partnership of Gains. Section 1. General Provisions. Article 105. In case the future spouses agree in the marriage settlements that the regime of conjugal partnership gains shall govern their property relations during marriage, the provisions in this chapter shall be of supplementary application. The provisions of this chapter shall also apply to conjugal partnerships of gains already established between spouses before the effectivity of this code, without prejudice to vested rights already acquired in accordance with the Civil Code or other laws, as provided in Article 256. Article 106. Under the regime of conjugal partnership of gains, the husband and wife place in a common fund the proceeds, products, fruits and income from their separate properties and those acquired by either or both spouses through their efforts or by chance, and, upon dissolution of the marriage or of the partnership, the net gains or benefits obtained by either or both spouses shall be divided equally between them, unless otherwise agreed in the marriage settlements. Article 107. The rules provided in Articles 88 and 89 shall also apply to conjugal partnership of gains. Article 108. The conjugal partnership shall be governed by the rules on the contract of partnership in all that is not in conflict with what is expressly determined in this chapter or by the spouses in their marriage settlements. Section 2. Exclusive property of each spouse. Article 109. The following shall be the exclusive property of each spouse: Number 1, that which is brought to the marriage as his or her own; Number 2, that which each acquires during the marriage by gratuitous title. Number 3, that which is acquired by right of redemption, by barter or by exchange with property belonging to only one of the spouses, and number 4, that which is purchased with exclusive money of the wife or of the husband. Article 110. The spouses retain the ownership, possession, administration, and enjoyment of their exclusive properties. Either spouse may, during the marriage, transfer the administration of his or her exclusive property to the other by means of a public instrument, which shall be recorded in the registry of property of the place the property is located. Article 111. A spouse of age may mortgage, encumber, alienate or otherwise dispose of his or her exclusive property, without the consent of the other spouse, and appear alone in court to litigate with regard to the same. Article 112. The alienation of any exclusive property of a spouse administered by the other automatically terminates the administration over such property, and the proceeds of the alienation shall be turned over to the owner spouse. Article 113. Property donated or left by will to the spouses, jointly and with designation of determinate shares, shall pertain to the donee spouses as his or her own exclusive property, and in the absence of designation, share and share alike, without prejudice to the right of accretion when proper. Article 114. If the donations are onerous, the amount of the charges shall be borne by the exclusive property of the donee spouse, whenever they have been advanced by the conjugal partnership of gains. Article 115. Retirement benefits, pensions, annuities, gratuities, usufructs and similar benefits shall be governed by the rules on gratuitous or onerous acquisitions as may be proper in each case. Section 3. Conjugal partnership property. Article 116. All property acquired during the marriage, whether the acquisition appears to have been made, contracted, or registered in the name of one or both spouses, is presumed to be conjugal unless the contrary is proved. Article 117. The following are conjugal partnership properties. Number 1. Those acquired by onerous title during the marriage at the expense of the common fund, whether the acquisition be for the partnership, or for only one of the spouses. Number 2. Those obtained from the labor, industry, work, or profession of either or both of the spouses. Number 3. The fruits, natural, industrial, or civil, due or received during the marriage from the common property, as well as the net fruits from the exclusive property of each spouse. Number 4. The share of either spouse in the hidden treasure which the law awards to the finder or owner of the property where the treasure is found. Number 5. Those acquired through occupations such as fishing or hunting. Number 6. Livestock existing upon the dissolution of the partnership in excess of the number of each kind brought to the marriage by either spouse. And number 7. Those which are acquired by chance, such as winnings from gambling or betting. However, losses therefrom shall be borne exclusively by the loser spouse. Article 118. Property bought on installments paid partly from exclusive funds of either or both spouses and partly from conjugal funds belongs to the buyer or buyers if full ownership was vested before the marriage, and to the conjugal partnership if such ownership was vested during the marriage. In either case, any amount advanced by the partnership or by either or both spouses shall be reimbursed by the owner or owners upon liquidation of the partnership. Article 119. Whenever an amount or credit payable within a period of time belongs to one of the spouses, the sums which may be collected during the marriage in partial payments or by installments on the principal shall be the exclusive property of the spouse. However, interests falling due during the marriage on the principal shall belong to the conjugal partnership. Article 120. The ownership of improvements, whether for utility or adornment, made on the separate property of the spouses at the expense of the partnership or through the acts or efforts of either or both spouses shall pertain to the conjugal partnership, or to the original owner spouse, subject to the following rules. When the cost of the improvement made by the conjugal partnership and any resulting increase in value are more than the value of the property at the time of the improvement, the entire property of one of the spouses shall belong to the conjugal partnership, subject to reimbursement of the value of the property of the owner spouse at the time of the improvement. Otherwise, said property shall be retained in ownership by the owner spouse, likewise subject to reimbursement of the cost of the improvement. In either case, the ownership of the entire property shall be vested upon the reimbursement, which shall be made at the time of the liquidation of the conjugal partnership. Section 7. Liquidation of the conjugal partnership assets and liabilities. Article 129. Upon the dissolution of the conjugal partnership regime, the following procedure shall apply. Number 1. An inventory shall be prepared, listing separately all the properties of the conjugal partnership and the exclusive properties of each spouse. Number 2. Amounts advanced by the conjugal partnership in payment of personal debts and obligations of either spouse shall be credited to the conjugal partnership as an asset thereof. Number 3. Each spouse shall be reimbursed for the use of his or her exclusive funds in the acquisition of property or for the value of his or her exclusive property, the ownership of which has been vested by law in the conjugal partnership. Number 4. The debts and obligations of the conjugal partnership shall be paid out of the conjugal assets. In case of insufficiency of said assets, the spouses shall be solidarily liable for the unpaid balance with their separate properties, in accordance with the provisions of paragraph 2 of Article 121. Number 5. Whatever remains of the exclusive properties of the spouses shall thereafter be delivered to each of them. Number 6. Unless the owner had been indemnified from whatever source, the loss or deterioration of movables used for the benefit of the family, belonging to either spouse, even due to fortuitous event, shall be paid to said spouse from the conjugal funds, if any. Number 7. The net remainder of the conjugal partnership properties shall constitute the profits, which shall be divided equally between husband and wife, unless a different proportion or division was agreed upon in the marriage settlements or unless there has been a voluntary waiver or forfeiture of such share as provided in this code. Number 8. The presumptive legitimes of the common children shall be delivered upon the partition in accordance with Article 51. Number 9. In the partition of the properties, the conjugal dwelling and the lot on which it is situated shall, unless otherwise agreed upon by the parties, be adjudicated to the spouse with whom the majority of the common children choose to remain. Children below the age of 7 years are deemed to have chosen the mother, unless the court has decided otherwise. In case there is no such majority, the court shall decide, taking into consideration the best interests of said children. Article 130. Upon the termination of the marriage by death, the conjugal partnership property shall be liquidated in the same proceeding for the settlement of the estate of the deceased. If no judicial settlement proceeding is instituted, the surviving spouse shall liquidate the conjugal partnership property either judicially or extrajudicially within 6 months from the death of the deceased spouse. If upon the lapse of the 6-month period no liquidation is made, any disposition or encumbrance involving the conjugal partnership property of the terminated marriage shall be void. Should the surviving spouse contract a subsequent marriage without compliance with the foregoing requirements, a mandatory regime of complete separation of property shall govern the property relations of the subsequent marriage. Article 131. Whenever the liquidation of the conjugal partnership properties of 2 or more marriages contracted by the same person before the effectivity of this code is carried out simultaneously, the respective capital, fruits, and income of each partnership shall be determined upon such proof as may be considered according to the rules of evidence. In case of doubt as to which partnership the existing properties belong, the same shall be divided between the different partnerships in proportion to the capital and duration of each. Article 132. The rules of court on the administration of estates of deceased persons shall be observed in the appraisal and sale of property of the conjugal partnership, and other matters which are not expressly determined in this chapter. Article 133. From the common mass of property support shall be given to the surviving spouse and to the children during the liquidation of the inventoried property and until what belongs to them is delivered, but from this shall be deducted that amount received for support which exceeds the fruits or rents pertaining to them. Chapter 5. Separation of property of the spouses and administration of common property by one spouse during the marriage. Article 134. In the absence of an express declaration in the marriage settlements, the separation of property between spouses during the marriage shall not take place except by judicial order. Such judicial separation of property may either be voluntary or for sufficient cause. Article 135. Any of the following shall be considered sufficient cause for judicial separation of property. Number 1. That the spouse of the petitioner has been sentenced to a penalty which carries with it civil interdiction. Number 2. That the spouse of the petitioner has been judicially declared an absentee. Number 3. That loss of parental authority of the spouse of petitioner has been decreed by the court. Number 4. That the spouse of the petitioner has abandoned the latter or failed to comply with his or her obligations to the family as provided for in Article 101. Number 5. That the spouse granted the power of administration in the marriage settlements has abused that power, and number 6. That at the time of the petition, the spouses have been separated in fact for at least 1 year and reconciliation is highly improbable. In the cases provided for in numbers 1, 2, and 3, the presentation of the final judgment against the guilty or absent spouse shall be enough basis for the grant of the decree of judicial separation of property. Article 136. The spouses may jointly file a verified petition with the court for the voluntary dissolution of the absolute community or the conjugal partnership of gains, and for the separation of their common properties. All creditors of the absolute community or of the conjugal partnership of gains, as well as the personal creditors of the spouse, shall be listed in the petition and notified of the filing thereof. The court shall take measures to protect the creditors and other persons with pecuniary interest. Article 137. Once the separation of property has been decreed, the absolute community or the conjugal partnership of gains shall be liquidated in conformity with this code. During the pendency of the proceedings for separation of property, the absolute community or the conjugal partnership shall pay for the support of the spouses and their children. Article 138. After dissolution of the absolute community or of the conjugal partnership, the provisions on complete separation of property shall apply. Article 139. The petition for separation of property and the final judgment granting the same shall be recorded in the proper local civil registries and registries of property. Article 140. The separation of property shall not prejudice the rights previously acquired by creditors. Article 141. The spouses may, in the same proceedings where separation of property was decreed, file a motion in court for a decree reviving the property regime that existed between them before the separation of property in any of the following instances. Number 1. When the civil interdiction terminates. Number 2. When the absentee spouse reappears. Number 3. When the court, being satisfied that the spouse granted the power of administration in the marriage settlements will not again abuse that power, authorizes the resumption of said administration. Number 4. When the spouse who has left the conjugal home without a decree of legal separation resumes common life with the other. Number 5. When parental authority is judicially restored to the spouse previously deprived thereof. Number 6. When the spouses who have separated in fact for at least 1 year, reconcile and resume common life. Or number 7. When after voluntary dissolution of the absolute community of property or conjugal partnership has been judicially decreed upon the joint petition of the spouses, they agree to the revival of the former property regime. No voluntary separation of property may thereafter be granted. The revival of the former property regime shall be governed by Article 67. Article 142. The administration of all classes of exclusive property of either spouse may be transferred by the court to the other spouse. Number 1. When one spouse becomes the guardian of the other. Number 2. When one spouse is judicially declared an absentee. Number 3. when one spouse is sentenced to a penalty which carries with it civil interdiction, or number 4, when one spouse becomes a fugitive from justice or is in hiding as an accused in a criminal case. If the other spouse is not qualified by reason of incompetence, conflict of interest, or any other just cause, the court shall appoint a suitable person to be the administrator. Chapter 6. Regime of Separation of Property. Article 143. Should the future spouses agree in the marriage settlements that their property relations during marriage shall be governed by the regime of separation of property, the provisions of this chapter shall be suppletory. Article 144. Separation of property may refer to present or future property or both. It may be total or partial. In the latter case, the property not agreed upon as separate shall pertain to the absolute community. Article 145. Each spouse shall own, dispose of, possess, administer and enjoy his or her own separate estate, without need of the consent of the other. To each spouse shall belong all earnings from his or her profession, business, or industry and all fruits, natural, industrial or civil, due or received during the marriage from his or her separate property. Article 146. Both spouses shall bear the family expenses in proportion to their income, or, in case of insufficiency or default thereof, to the current market value of their separate properties. The liabilities of the spouses to creditors for family expenses shall, however, be solidary. Chapter 7. Property regime of unions without marriage. Chapter 7. Property regime of unions without marriage. Article 147. When a man and a woman who are capacitated to marry each other, live exclusively with each other as husband and wife without the benefit of marriage or under a void marriage, their wages and salaries shall be owned by them in equal shares, and the property acquired by both of them through their work or industry shall be governed by the rules on co-ownership. In the absence of proof to the contrary, properties acquired while they live together shall be presumed to have been obtained by their joint efforts, work, or industry, and shall be owned by them in equal shares. For purposes of this article, a party who did not participate in the acquisition by the other party of any property shall be deemed to have contributed jointly in the acquisition thereof if the former's efforts consisted in the care and maintenance of the family and of the household. Neither party can encumber or dispose by acts inter vivos of his or her share in the property acquired during cohabitation and owned in common, without the consent of the other, until after the termination of their cohabitation. When only one of the parties to avoid marriage is in good faith, the share of the party in bad faith in the co-ownership shall be forfeited in favor of their common children. In case of default of or waiver by any or all of the common children or their descendants, each vacant share shall belong to the respective surviving descendants. In the absence of descendants, such share shall belong to the innocent party. In all cases, the forfeiture shall take place upon termination of the cohabitation. Article 148. In cases of cohabitation not falling under the preceding article, only the properties acquired by both of the parties through their actual joint contribution of money, property, or industry shall be owned by them in common in proportion to their respective contributions. In the absence of proof to the contrary, their contributions and corresponding shares are presumed to be equal. The same rule and presumption shall apply to joint deposits of money and evidences of credit. If one of the parties is validly married to another, his or her share in the co-ownership shall accrue to the absolute community or conjugal partnership existing in such valid marriage. If the party who acted in bad faith is not validly married to another, his or her shall be forfeited in the manner provided in the last paragraph of the preceding article. The foregoing rules on forfeiture shall likewise apply even if both parties are in both faith.